Your Honor, I'm here appearing as a special appearance to challenge the sufficiency of the court.
So I have received communications from a Lloyd Eugene Kleinberger on a notice of infraction, RL 0014690. Is there a Lloyd Eugene Kleinberger present? All right, come forward, sir. So I'll let you know that this system is manually operated, so you'll have to tap the right button. The microphone will go red when it's time for you to speak and you want to be on the record. When you're done speaking, please tap the right button again. The red light will go off and it will stop recording. This matter is on for an infraction. So you are Lloyd Eugene Kleinberger, correct, sir? Sir, hang on, sir. Hang on. There you go. All right. As to, are you Lloyd Eugene Kleinberger?
I am Lloyd Eugene Kleinberger, a living, breathing free man.
Very well, sir. You're answering as Lloyd Eugene Kleinberger. This is now the hearing for the notice of infraction for a red light RL 0014960. I've had a chance to go over any pre-trial or pre-infraction notices. There's a notice and challenge to jurisdiction listed to King County. That's denied. After reviewing the motion, we're in the proper court, the proper venue, and discovery and interrogatory. It's not to me. I just have a copy. There's no response needed by the court on that matter. I am not the one that holds any discovery. I am not the one bringing the charge. This is the venue for which the charge will be heard. There's the subpoena. The officer is present. The subpoena was served and Officer Keller is present. And the same notice and challenge to jurisdiction, which I've denied. And another copy of the discovery and interrogatory. An offer to settle. I'm not a party to that, so I will skip over that as well. All right. Sir, you are here on a contested infraction for a red light violation alleged to have occurred on 3/12/2026. Are you ready to proceed?
Yes.
All right. I'll first turn to the city's case. That is going to be the evidence presented. The affidavit says, I'm a fully commissioned officer of the Paulsville Police Department. I'm authorized to enforce the laws of the state of Washington based upon my review of photographs and or a video recording made by an automated photo enforcement camera. I have reasonable grounds, probable cause to believe, and do believe that on the date and the time and location indicated above, the operator of the vehicle described above was in violation of RCW 4661.050 as adopted by the Paulsville Municipal Code 10.10. The electronic images showing the vehicle and its license plate portray a fair and accurate representation of the location listed above and indicate that the vehicle operator was facing a steady red traffic control signal when the vehicle failed to stop and remained stopped at the clearly marked stop line or other stopping point. A records check has been completed through the appropriate state licensing department, and the registered owner of the vehicle at the time of the violation is our named above, and that is Janet Louise and Lloyd Eugene Kleinberger. I certify under penalty of perjury under the laws of the state of Washington the foregoing is true and correct, and I'm entering my authorized user ID and password to authenticate the issuance of this notice of infraction. Madam Clerk, I'm going to join you on the Zoom for a share. Give me just one moment, sir. I want to connect the screen so that you can see what I'm considering. Have you had a chance to be able to review the online photos and video?
Yeah.
Okay, that's what I'm going to be reviewing next, sir. Give me just one moment. All right, sir. So what I'm going to take into consideration here is Exhibit A. Let me make this large enough so that you can see it. Basically, these photos, I am looking for a Honda Accord 2003 with a license plate of CMC 6336. This first picture usually is to identify if you can. Usually I can make this bigger. If you can see here, the lights are red. The suspected vehicle is well behind the red line at the time that the traffic control devices have illuminated in red. So the vehicle has not passed the stop line at the time of the red light. The vehicle is in the far right turn lane. Looking at the license plate, CMC 6336. Yes. And then finally the video clip, which we can see much larger. And so the light is red. The vehicle approaches. No stopping whatsoever. And the vehicle then continues to the right. All right, sir. I find a sufficient basis that the city has so far shown that there is a preponderance of the evidence, but I'll turn to you. Do you have any motions or testimony you'd like to offer in defense of the alleged infraction?
No, sir. I'm not the defendant.
Do you have anything else to add? You've subpoenaed the officer. Do you need to swear them in, have any testimony for them, or any other reasons to have him here?
Yes, I have questions for him.
Okay, so can you give me an offer of proof of what your intended line of questioning is?
I'm sorry, I'm not sure exactly what you mean by that.
Well, give me an example of the types of questions you want to ask so that I can make a determination as to whether or not they're relevant to this proceeding.
Um,
In other words, are you going to ask him questions about how he came to the determination or what he observed or anything that he would have personal knowledge to?
I have a lot of questions about determining the validity of his charges.
Well, that's my job, sir. And so you can speak to me about that. Do you have something more specific?
Um, I do, but I'm trying to figure out how to state it.
That's right. Just go ahead and give me an example, sir. That's okay. And then if it's something that falls within the scope, I can swear him in and let you ask that question.
All right, the first question is, Officer Kelly,
Well, ask me.
Oh.
You're letting me know what you're intending
Okay.
to ask.
I would like to ask him if he read the discovery and interrogatory, and has he had time to read it and consider it, and did he submit any answers?
Okay. So are you alleging that there's an interrogatory that was attempted? In other words, why would he have knowledge of an interrogatory? This is an infraction hearing, so interrogatories are not allowed under the rule. So I can't imagine that he's answered that.
Okay,
could.
I filed it with the court.
Oh, I know you filed it,
Yeah.
but it's not permitted. There's no rule that allows interrogatories in an infraction. So I need to find the relevance of that line of questioning. Interrogatories are not allowed under the infraction rules. So I would anticipate that the answer is going to be no, but I'm not even sure he would be aware that there was an interrogatory. So I'm gonna decline to allow that question. It's not within the scope of this hearing.
I would also like to ask how he feels about the US Constitution, the Washington State Constitution, and my rights under the Constitution.
Sure, I would not find that relevant. The officer would most likely testify that he has taken an oath to uphold the very same, and that's why he holds the job that he does. I don't see his feelings when it's up to me to interpret the law. That would be something that would not be within, it wouldn't be relevant to this hearing. Go ahead, sir.
I'd like to know if Officer Kelly or anyone informed me of my rights to the Miranda rights to remain silent and not testify against myself.
All right, very well, sir. Do you believe that the Miranda rights that they apply here in an infraction style hearing, a civil hearing that is not one that you can lose your liberty or were ever taken into custody? Do you believe that the Miranda rights are required here?
I guess I would, yes.
Okay, I will let you know that they don't. It's an infraction, so that would not be a relevant question, sir. You're not entitled to Miranda advisements. Go ahead. So I'm going to decline to allow you to ask that question.
Okay, Officer Kelly,
But just a second, it's Officer Keller, but that's okay.
okay. Officer
ahead.
Kelly, he initiated a claim in the Paulsville Municipal Court. And
When you say claim, I need that's a term of art. What do you mean by a claim?
Proceeding.
What,
Proceeding.
yeah,
Well, you've been cited for a violation of a law that's called a notice of infraction.
okay,
Is that what you're speaking to?
I guess that is, yes.
Okay, go ahead.
Okay, when he did it, on the information that I got, it was to Janet Louise and Lloyd Eugene Kleinberger, all in capital letters. And Janet Louise and Lloyd Kleinberger in capital letters do not exist. So I would
Well-
move that this case be dismissed.
Motion is denied. You've responded that you are Lloyd Eugene Kleinberger. You are appearing here today. Is that correct, sir? And you've identified yourself as that name? Because if not, I can't hold these proceedings.
A free man.
Are you Lloyd Eugene Kleinberger?
No capital letters, a free man, yes.
Absent the conditions, if you're responding under that name, then you can sit there and respond because you're that person. But if you're not that person, then you cannot hold this hearing. You're not an attorney. You can't practice law for somebody else. So I just want to be clear for the record. Are you, without conditions, Lloyd Eugene Kleinberger? Notice I'm speaking verbally, so there are no capital letters. Would you like more time to think about that answer, sir? I do have two other matters that still need to proceed today. Because it would be incorrect for me to proceed if you are not, in fact, Lloyd Eugene Kleinberger.
I am Lloyd Eugene Kleinberger.
Okay, thank you, sir. So I will deny that motion based upon the evidence presented by your affirmation of your name. Go ahead, sir. Do you have any other motions?
For you, who is the plaintiff in this case?
The city of Paulsville.
Uh, When I got the paperwork, I believe Officer Kelly did not indicate a plaintiff. And the paperwork also shows other, the Paulsville Police Department as an additional plaintiff, so it's confusing.
I will take that as a motion to dismiss for improper notification. I would find that the notice of infraction that is in the record is sufficient. You, the named party, are appearing. You are made aware of the matter, date and time, and all the information, and all of the discovery was supplied to you via electronic means for which you've already admitted that you have reviewed. So the notice of infraction was sufficient to put you on, shall we say, sure enough footing to be able to appear when necessary, be notified of the charge, notify you of the potential imposition of $145. So I will deny that motion.
Your Honor, I'm here appearing as a special appearance to challenge the sufficiency of the court.
I just want to be clear, you're challenging the sufficiency of the court or the sufficiency of the evidence being presented by the city in this court? There's two different approaches. I want to make sure I'm taking the correct one.
Please restate that.
You have said that you are challenging the sufficiency of the court. I want to make sure that I understand that motion, so I'm asking for clarification. I'm asking you to clarify. Do you mean that you are challenging the sufficiency of the evidence in this court? Or are you challenging the sufficiency of this court in general? In other words, its reason for being, its ability to be? Because those are two different responses, and I just want to answer correctly.
I believe that's the court in general.
I will deny that. This court is established not only through court rules and the proper statutory authority as a court of limited jurisdiction sufficiently operating in the state of Washington. So that is denied, sir. Do you have any other questions or any other motions you'd like to make, sir?
Based on what you said, I believe you would deny any other questions I have.
No, sir, I'm trying to make sure, I'm sorry that you feel that way. I'm trying to handle these as appropriately and individually as they are presented to me. Please do not take the fact that you've lost all of them as an indication that you will lose all of them if asked. I'm taking them one by one as any disinterested magistrate should do. And if you have any other motions, please, without any type of penalty, please go ahead and make those. Otherwise, I do need to move forward.
Considering that Dun and Bradstreet lists the city as Paulsville, a profit corporation doing business as municipal court, also a for-profit corporation. Dun and Bradstreet also indicates that the city of Paulsville is doing business as the police department for profit. Does that produce a conflict of interest, seeing as how everybody is working for the same corporation?
Is that question to me, or is that the one that you want to give to Officer Keller?
I would have asked Officer Kelly that, but based on what we have been talking about, I guess I'm addressing it to you.
Okay. Quick civics lesson. Oh, hang on.
Be fine too.
Well, you've addressed it to me, so let me go first. Over there are the legislative chambers. That's the first branch of government, the legislative branch. They're the ones that get together. They discuss what they want to implement. They do so through municipal code. Once they have agreement, after listening to the public, they enact municipal code. Those codes or ordinances are then sent to the executive branch. And I'm pointing over here because there's the police department, and up on the third floor is the mayor's office. That's the executive branch. They're the ones that then take the power that they were granted by the legislative branch to execute those ordinances and any adopted state statutes. That executive branch then does their own investigation. They act under the authority for which they were granted, and they make their decisions. The third branch, for which you're seated in today, is a separate branch. That's the judicial branch. I am the head of that judicial branch. I am the presiding judge in this court. Yes, Paulsville, Dun and Bradstreet, and however that may affect how you think this should be answered. Paulsville Municipal Court is an entity of the Paulsville Municipal Government, and I am a disinterested third branch, not related to the executive branch, not related to the legislative branch. That is why you have a hearing today, because the city, through its executive branch, the police department, has given you a notice of infraction. The government has said, we believe that you violated an ordinance and therefore you are going to be fined. You can pay it, you can request a hearing. You've requested a hearing. That then goes to my branch, where I hold a fair and impartial hearing, where the city brings their representative that you have subpoenaed, and I will hear from both parties to be able to interpret the law, which is my job. So whether that poses a conflict, I would have to say it does not, unless you've seen something specific that leads you to believe that I am conflicted in hearing your matter. Per se, I am not conflicted in any way, sir. You said you wanted to ask the officer that question?
That was my original intent.
Okay, so let's say he believes there is a conflict. What remedy? Let's just take this to its logical end. What remedy do you believe that you would be entitled to, even if he said, yes, because I work for the city, I would? Is a conflict different than bias? I'm not sure of what question you're asking. Because he's a fact witness. So are you saying he's conflicted because he has personal knowledge and works for the city?
Not knowing the nice gentleman, there could be that position where he thinks that it's best for the city to find people.
Oh, to find people. All right, sir. If you want to ask, because I think that falls a little bit more into bias, which would be relevant to the officer's understanding and formation of his mind in bringing a potential charge. I think that that would be relevant under bias. Do you want me to swear him in to allow that question to be asked?
Sure.
Officer Keller, this time can I have you raise your right hand, please? Do you swear or affirm the testimony you're about to give in this matter is the truth and nothing but the truth, sir?
Yeah.
All right, having been sworn in, sir, I'm going to allow Mr. Kleinberger to ask you a question. Go ahead, Mr. Kleinberger, if you'd like to ask that question.
Do you feel because of the relationship between the police, the municipal court and the Paulsbo, that there's any possibility that you would have a bias in trying to bring in more money for the city?
No, sir. All right, any further questions?
I guess not.
All right, sir. Would you like to make any presentation of evidence or have any witnesses sworn in defense?
No, sir.
All right. Thank you. Then I'm going to release the witness.
That's fine.
All right.
Thank you.
Thank you, Officer Keller. You are hereby no longer under oath and free to go about your day. All right, Mr. Kleinberger, if there's no further argument, I'm going to take the evidence that was presented by the city. I do find by a preponderance of the evidence that the infraction was in fact committed by the registered owners. There's a presumption in the law that the registered owners are the drivers. I've heard no testimony that overcomes that presumption, and therefore I will find it committed and impose the amount of $145. You have 30 days to pay. If you need more time, you can set up a free payment arrangement. The good news is, if there's any to be had today, sir, is that this is, even though you were, the driver was in motion, this is not considered a moving violation. So it will not be reported to insurance and will not be used in that way because it does not go to Department of Licensing. The law requires these to be treated in the same vein as a non-moving parking ticket. So it will not have that secondary effect, but the $145 will be imposed as a result of the finding of committed today based upon the presentation of evidence. Once you have your order, sir, you are free to leave. If you want to set up payment arrangements, you can do so upstairs. All right.
Can I ask you what evidence you have that I was driving?
You can review the record, sir. I don't have to show any evidence that you were driving. The law has a presumption in there that the registered owner is the driver, and that's why I made the finding that you did not overcome that rebuttable presumption. All right, that'll conclude the hearing, sir. Thank you.